Hello, I'm Lauren Cadillac with Cadillac Law. I'm coming to you today with a legislative update, new Supreme Court rules regarding evictions in the state of Texas. Nothing I say here is legal advice, and nor am I creating an attorney-client relationship. This is just information I am sharing with you. Prior to COVID-19, Texas was an incredibly landlord-friendly state. Very easy to evict tenants, very smooth process. However, because of COVID and federal rules and all kinds of rules, it became very difficult to be a landlord. There's a good 5-year period, it kind of sucked. It's really hard to get people out now, mainly because the JP courts tend to not be attorneys, would often hear defenses that really don't apply in that courtroom. The legislature said on September 1, a law went into effect that said Supreme Court needs to write new rules for evictions. Those rules are written, and we have the rules that will begin January 1, 2026. That's what we're going to review today. Right now, though, these rules are under review. There's still a discussion period, and they won't be codified until February. So there is a chance that in February, I'll be redoing this video with different rules. But for now, these rules will carry us from January 1st until the codification of whatever new rules we have. Okay, so let's dig in. I'm actually going to go through the suggested changes memo and the rules memo as it is, and we'll talk about how it was before, how it is now. Okay, so now the rule allows you to do a notice to pay rent or vacate, or a notice to vacate that can run concurrently with the period of the time for the tenant to respond to the eviction suit. Okay? You are now allowed to send notice electronically so long that there's an agreement in the lease or in writing that says you can give electronic notice. So in the past, everything had to be posted on doors, but if you put a provision in your lease that communications can be done electronically, you can simply email them the notice, okay? A major change is requiring the eviction suit to be a sworn petition. In the past, just kind of filed it, right? Now you have to swear under penalty of perjury that the facts inside the petition are true and correct. Also, there were so many times where a tenant could find a defect in the petition and have the entire eviction tossed out. That has now been taken away. If the defect could be cured by an amendment to the petition, then they have to go forward with the eviction. So pretty much every defect can be cured by an amendment, and there's really no way to win on that type of technicality starting January 1st. So that's great news for landlords. The bill requires the constable to make diligent effort to serve within 5 days, and you have to have the eviction trial no sooner than the 10th day, no later than the 21st. They could not hold trial any earlier than the 4th day after the tenant was served, and then there's no continuance unless both parties agree in writing. All right, this also disallows a JP court to hear a defense of a title issue. Now, the Justice Court will only be able to adjudicate actual possession, and they've never been able to adjudicate title. But now they will only be allowed to look at actual possession, and there will be no counterclaims or joinder claims permitted in eviction suits. Okay? This part happens to be my favorite. This allows for a summary disposition. Now, I've told you about motion for summary judgment before. Basically, if there's no question of fact, the judge can review the file and make a ruling on law. Okay? This allows a landlord to do a sworn petition and a sworn summary disposition at the same time, okay? They need to be filed together, and there needs to be a specific request to the clerk to include on the citation the summary disposition. This is going to be fantastic for apartment buildings, things where tenants didn't pay rent, where it's on its face, easy, cut and dry. They didn't pay rent. Not as easy maybe with damages, they damaged it, they have to get out, those kind of things. But very black and white. We have a lease, they didn't pay. A sworn petition, the notices, and the summary disposition can all be served on the same day. And in fact, the summary disposition has to be served and you have to mention it in your citation. Having that eliminates the need for a trial. The judge can then make a ruling if there are no facts at dispute. The judge can make a ruling on the summary disposition without a trial. Now, the tenant is allowed to respond, but they only have 4 days. So if you file the eviction along with the summary disposition, all of those together, the tenant will have 4 days to write a written response, okay? And when a summary judgment has been issued by the court, again, no trial, right? There's no need for a trial. They're just going to read and review, sign orders. They must mail that judgment within 48 hours to the tenant, all right? Excellent news for landlords in Texas. Now, big changes to the appeal process. Prior to this, people could file an appeal and buy themselves like another 6 weeks easily. They could file an appeal even though they know damn well they didn't pay their rent, right? Now, in order to file the appeal, the tenant must make a sworn declaration under penalty of perjury that they have a good faith belief that they have a meritorious defense. Well, if you didn't pay your rent, you don't have a meritorious defense. It's not going to be a lot of appeals. This is really going to limit the appeals because these people have to swear that they're not appealing just for delay, and the majority of eviction appeals are in fact just for delay. Okay, so the court has to have the appeal with them within 10 days, and then the county court has to have the trial within 21 days. So now an appeal is only going to buy you 31 days, not upwards of 6, 7, 8 weeks. That's great for landlords. Also great for landlords is now a requirement to pay the rent to the registry's office. So nobody cares that you don't have money. You have to go pay this rent to the registry office when it's due. And it allows the landlord to go take those funds whenever needed. So if you're going through the appeal process and you pay, on the 1st to the registry, by the 3rd, the landlord can go have that money and make his mortgage payment on time. Whereas in the past, these things had to be fully adjudicated and the full amount would be released to the landlord at a later date. So this is great news for landlords. This is great news for real estate investors in the state of Texas, okay? The writ of possession changes for a tenant who failed to pay rent, and it establishes that a writ of possession is a ministerial act, not subject to review or delay. So it used to be an act where you could have it reviewed, you could have it delayed, like real laws applied to you. That is no longer. That is no longer. All right, so this all takes effect on January 1st, but what you need to know is that this may be changed a bit before it's codified and becomes the written law. This is the written law right now, but it's not going to make it to the code books until the actual process has gone through and they finalized and made little tweaks. This is excellent news for Texas landlords. This is excellent news for people who are dealing with squatters, etc. This is really good legislation for the forward movement of Texas real estate investment. So, thank you very much for your time. I hope you've learned something. If you have any questions, do not hesitate to call us 972-845-1200.